this is a legal case. We are talking about state statutes. I will tell you as a lawyer that when anybody says the spirit of the law, then you know you got it. When somebody has to retreat to the word spirit, it means that the arguments that they're making are not in the statutes textually. When you are in court, when you're in trial, and you hear opposing counsel say, oh, well, that's the spirit of the law. That's what the legislature surely meant. I'm sure that if the legislature had more time, then they would have said, they would have clarified, they would have put in writing. Whenever you hear someone say it's the spirit of the law, you know you got it.
Respectfully diverging to what family lead attorney said in his video, he is absolutely incorrect. And Officer Brandon Tatum is actually correct. And as someone who has actually lectured on this as a college criminal justice professor, I'd like to clarify for my criminal justice students and the public that the courts have long recognized the spirit of the law, more formally known as legislative intent, as a legitimate means or method of interpretation. Now, this is called purposivism, and it stands alongside textualism in the legal toolkit. You don't got them. It means the courts often interpret laws based on why they were written, not just the bare text. And this matters when literal readings could undermine the very public interest the law was designed to protect. So he called you all his legal students in law school. You would have failed that class. Strap in, my criminal justice epistemological students. By the way, epistemology is the science of knowing and questioning what it is we truly know. Epistemologists are philosophers of knowledge. They don't just accept answers, they interrogate the source, the meaning, and the validity of what we can call truth. So in this space, we don't just understand, we aim to know. Because when you know, based on sound reasoning, history, and legal principle, you don't argue with noise. You stand on knowledge. And that's what separates opinion from education. You ready? Sorry, lead attorney, outstanding guy, but let's go. Let's refresh on purposivism. Purposivism stands alongside contextualism or textualism in the legal toolkit. Courts often interpret laws based on, again, why they were written, not just the bare text. I see a lot of you all focusing on during. We're going to talk about that because the literal readings could undermine the very purpose interest that the law was designed to protect. Now, I like to go to the United States Supreme Court and other court cases. So here are some U.S. Supreme Court cases supporting purposivism. Church of the Holy Trinity versus United States, 143 U.S. 457, 1892. A thing may be within the letter of the statute, and yet not within the statute, not within the spirit, but the intention of its maker. Zuber v. Allen, 396 U.S. 168, 1969. Statutory construction is a holistic endeavor. A provision that may seem ambiguous in isolation is clarified by the remainder of the statute and by the statute's overall purpose. United Steelworkers versus Weber, 443 U.S. 193, 1979. The Supreme Court upheld affirmative action provisions based on the legislative purpose addressing racial inequality, even though Title VII's literal language could be read otherwise. One of my favorite cases out of California, Brown versus Entertainment Merchants Association, 564 U.S. 786, 2011. Even Justice Antonin Scalia, he's known for his unwavering textualism. He took a broader view to defend video games under the First Amendment. California tried to restrict the sale of violent video games to minors, arguing that such content was harmful. But Scalia rejected that argument. Why did he? Because expressive violence has long been part of the stories we accept in society. Scalia wrote, y'all remember the Grimm's fairy tales? For example, they are grim indeed, as her just deserts for trying to poison Snow White. The wicked queen, she's made to dance in her red hot slippers until she falls dead on the floor. Cinderella's evil stepsisters, they had their eyes poked out or pecked out by what? Doves. What was his point? We don't ban books or media just because they include violence. And we don't distort the law to fit emotional panic. We look at the historical and cultural context and apply the law with purpose, not fear. He leaned into expressive tradition, not statute text, to protect First Amendment rights. That wasn't strict textualism. That was judicial insight rooted in what? The spirit of the law. Now, let's go to this traffic stop we're talking about. Let's look at Florida law and public safety. So, Florida courts apply the same approach, especially when public safety is at stake. The Florida Supreme Court, the highest court of the land, decided this in State versus Egan, 287 South 2nd 1, Florida, 1973. And I quote, statutes enacted for the preservation of the public health or safety are to be construed liberally in favor of the public interest and to effectuate the purpose of the law. Come on, lead attorney, right? Because this is a Florida Supreme Court decision. It is what's called a binding opinion, a binding holding on all Florida courts, including the court that would handle any challenge to the Jacksonville traffic stop. Now let's apply this to the headlight statute. Florida statute 316.217 states headlights shall be displayed during, and that's what he kept focusing on, the word during, any rain, smoke, or fog. The word during is what the lead attorney tried to dissect literally, but that's the wrong lens. Under a liberal construction for public safety, the statute's purpose is driver visibility, and it comes first, not just for the driver, but for the public. The Florida Supreme Court would agree. That means whether it's heavy rain or a light drizzle, visibility is impaired. You don't wait for a meteorologist to certify it's raining enough. You turn on your lights because the point is to be seen and to see others. The statute doesn't exist to protect clever interpretations. It exists to protect lives. And if you're going to be in law school, 1L, 2L, 3L, you got to use the law. You didn't hear him one time cite cases to support his argument. Police officers in their reasonable interpretations, right? There's this idea that officers must interpret the law like lawyers. This is also incorrect. And the United States Supreme Court addressed this as well in Heien versus North Carolina. That's Heien, Heien versus North Carolina. In that Supreme Court case, the court held that even a mistaken interpretation of law can justify a stop as long as it was a reasonable mistake. The court held in Heien, a police officer's reasonable mistake of law can still give rise to the reasonable suspicion pursuant to Terry versus Ohio necessary to uphold a traffic stop under the Fourth Amendment. Police officers are not required to parse statutory text like legal scholars. They are required to act reasonably in reasonably informed ways based on this thing called training and experience. So when an officer stops a driver for failing to activate headlights in the rain, that's not a technical error. That's a valid application of the law's purpose. So here's a final word. See, that's the beauty of teaching criminal justice. You don't need a law license to help people understand how the law works. You just need to understand legal concepts, know how to brief cases, cite them in your arguments. You didn't do that once. And apply those concepts to real life events. Gatekeeping legal understanding behind the bar exam or law licenses is how you keep the public confused. And that's by design. But the law belongs to the people, and the courts only borrow it. And we as educators, knowledgeable officers, and instructors are here to help the people read it, interpret it, and use it. Sorry, lead attorney, but I had to do it to you. This is Instructor Mike, and you've been trained. No matter which way you're coming, that traffic stop might have been awful. There could have been other ways that I, even as a former active police officer with this knowledge, might have done it differently. But that doesn't mean that the way they did it, ipso facto, or by that very fact, was unlawful. This is Instructor Mike, and you've been trained. Go follow the lead attorney. He gives great advice on or legal education on a lot of things, but on this one, lead, salute. You're wrong. Brandon Tatum was right.